Well, aloha and welcome everyone to our ongoing series of Grassroots Institute seminars. I'm Keli'i Akina, as Joe said, President and CEO of the Grassroots Institute. Today's topic is safety versus liberty. What is the legal basis for suspending civil rights during a time of crisis? And I want to tell you that we appreciate you joining us today. We have 237 registered participants as of this morning, and a much larger audience also watching on Facebook. And so thank you for taking the time. We'd love to have your questions if you are a registered participant. You can submit your questions at any time, and at 20 minutes after Robert Thomas starts today, what we're going to do is give you the opportunity to have your questions answered. On April 21st, I hope you're available then, because we do another webinar with two guests. It's a panel. Sandy Ma, the Executive Director of Common Cause Hawaii, and Brian Black, the Executive Director of the Civil Beat Center for Public Interest, Law and Public Interest. We're going to be talking about how government transparency in Hawaii has been affected by the coronavirus crisis. So you don't want to miss that. That's at noon on April 21st, and you can sign up on our website. Well, let's get started now. We are living in extraordinary times. While our state and indeed the whole world are focused on the public health crisis of the coronavirus, far less attention has been paid to the encroachment upon our civil liberties. Curfews, stay-at-home rules, suspension of the state's open meeting laws, these are just some of the measures that have been taken by our state and local officials to deal with the pandemic. But I'd like to raise this question, and I'm sure you thought about it. How far should the government go in restricting our civil liberties in the name of health or safety? With the recent loss of over 200,000 local jobs, how much economic damage is justified by government response to the virus? At the Grassroots Institute, we stand for the cherished values of individual liberty, economic freedom, and limited accountable government. Most of us have to agree that never in our lifetime have we seen the curtailment of these constitutionally protected values as we do now. Our featured speaker today is a good friend. He's a Grassroots Institute scholar, Robert Thomas, a nationally recognized takings expert and a director with the Honolulu law firm of Damon Key, Leong, Kupchak, and Hathaway. Thomas specializes in property and land use issues, including eminent domain, inverse condemnation, regulatory takings, property rights, and water rights. He's tried cases in Hawaii, California, and the federal courts, and he's appeared as counsel on behalf of landowners in Friends of the Court filings before state appellate courts, state Supreme Courts, and the US Supreme Court. He has a nationwide practice. He's also the inaugural Joseph T. Waldo Visiting Chair in Property Rights Law at William and Mary Law School in Williamsburg, Virginia. And he recently completed a year as chairman of the American Bar Association section on state and local government law. He continues as editor-in-chief of the section scholarly legal journal on municipal law issues called The Urban Lawyer. And many of you may know him from his regular blog publications, inversecondemnation.com. Now, after Robert's presentation, which will take place very soon and will last about 20 minutes, you'll have an ample opportunity to have your questions fielded. Just submit them in writing to us and Joe will announce them. But first, let me turn to Robert and welcome you to the show today. Robert, you are away from your home, Hawaii, right now. You're near Sonoma Valley. Thanks for joining us today, Robert. Aloha.
All right, thank you, Keli'i. It's a real pleasure to be here.
Well, you know, if you have to be holed up in a house somewhere, being in wine country in the vineyards has some compensation to it, I hope.
Yeah, you know, it's a gilded cage, and I do have my University of Hawaii hat, you know, to keep me reminding of my 808 roots, so there's that.
Well, before you begin, many of us are wondering about whether the government has the right to infringe upon constitutional liberties during a time of crisis, and if so, to what extent. I hope you'll cover that question as well as others, but take it away and we'll be back with you with Q&A in about 20 minutes. Okay, Robert?
Very well, thank you. And let me first share the screen here. My locals, I'm going to give you guys a couple of pictures and just something interesting, more interesting perhaps than me to take a look at here. Let me share that. And can you, Joe, am I good on the
yeah, looks good.
slide? Okay, very good. And you know, the short answer, there's a long answer like everything else lawyers do. There's a long answer and then there's the short answer. And we're going to hold off the short answer for a couple minutes just to give you a sense of where we're going today. We've got, the title is Safety and Freedom. Are there limits to lockdowns? And of course there are limits. And I know I can't see you all, but Joe and Keli'i tell me we have participants from all over the country, not just Hawaii. So I better say good evening to some of you who are joining us, especially from the East Coast. The short answer, let's get to the short answer. Yes, there are limits. And of course, like everything else in the law, the questions are really around the edge. What are those limits and where are those limits located? So what I'd like to do is to spend the next 20 minutes or so downloading to you how I look at that question as a lawyer, and not so much to discuss what our government's policies should be or whether our government is responding correctly to the crisis, from a scientific or policy standpoint, but rather to try to give you some insight about how judges and courts will evaluate any challenges to the government's emergency powers. So it's really not a discussion about what is right and wrong and should we be shutting down this or doing quarantines or other things, but more about sort of the practical realities of how judges and courts will look at this. And this, first of all, reminds me of something I'd like you to keep in mind as we progress. If I were to ask you, how many constitutions do we have? One answer might be, well, the US Constitution, and there's one, and that comes to mind when we talk about the Constitution, and we have this shorthand for it, right? We say the First Amendment, the Fourth Amendment, and the like, when we're really talking only about the United States Constitution. Some of you might say, no, we have 51 constitutions. And you'd be right, because in addition to the US Constitution, each sovereign state of the Union, Hawaii included, has its own different constitution that has in some cases equal force or in some areas greater importance in the powers that it delegates to various branches of government and the rights that it recognizes. But my theory that I'm getting at least for this initial portion, is that we really have two constitutions. First, the legal constitution that we lawyers know and we study and debate, full of these detailed, sometimes inexplicable nuances. And then there's the popular constitution, the constitution that exists in all of our minds and in our culture. Most people don't know, for example, the detailed contours of First Amendment doctrine, but we all know that we have the right to free speech. This is what I call the playground constitution. The rules we somehow learned over the years that in our minds have solidified into rules of law that we all for some reason just follow. The classic case of that is the finders, keepers, losers, weepers, right? Try to convince any kid that this isn't a binding rule of law. And similarly, try to convince an adult that the US is a republic and not a democracy really doesn't tell us anything about the actual legal constitution's guarantee of a Republican form of government. Good luck with that argument. And my point to all of this is that I'm going to ask you to try today to separate out the legal constitutional principles that I'm talking about, what I deal with every day, from the playground constitution of what the coffee klatch might think the Constitution requires, or maybe even you think the Constitution should require if only we did it right. And with that in mind, let's begin. Dr. Akina asked me to give you some takeaway points. So here is my first. The big competing concepts that we're going to be talking about today are illustrated by, I think, two things. First, the legal constitution, and contrary to some folks' playground constitution, the important point is that the legal constitution is not suspended during times of emergency. That's so important, I'm going to say it again, because if you take nothing else away from today's conference, it's this: your constitutional rights are not suspended in times of emergency. The Constitution has that baked in. It was designed to work equally as well in times of calm as in trying times as we are now experiencing. The Supreme Court reminded us of this in a case decided during the Great Depression. You talk about calamities. And forgive me for reading this to you, but the court is worth quoting at length. Emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power granted or reserved. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were not determined in the light of emergency, and they are not altered by emergency. So please, takeaway one, strike from your mind any idea that our rights are somehow suspended in a real or even an imagined emergency. And what this tells us is that we should always be good citizens, skeptical of government powers that limit our rights. And this doesn't necessarily mean that you go out and file lawsuits every time you feel like one of your rights is being infringed, but that it remains your duty as a citizen to monitor and question the leaders we elect. You know, on the other hand, and this is sort of the second takeaway power, is this: spam. Every Hawaii's person's favorite plan B, right? I raise this not to suggest that, you know, often in life the answer doesn't lie in the law, but that you have an obligation to control and look out for your own. Choose your battles wisely. Are we all chafing under the current restrictions? Oh boy, very likely, right? Are some of us truly suffering? I don't think there's any doubt about that. Might the law give you some relief? Well, maybe. Whether it does, you know, and whether it does or it doesn't or not, you know, spam up, right? Don't necessarily rely on the courts to handle your rights and protect your safety, or your government officials to protect your safety. If they tell you, well, you can go to the beach, does that mean you go to the beach? No, you stay home and keep your spam. Another thing I'd like you to take away from today is, let's dispel the notion that we're in a war. This emergency isn't a war, and it shouldn't be treated as such. You know, for instance, because in a war, courts may even be less willing to consider valid objections, and you only need to know of the infamous Korematsu case and the interning of American citizens, justified at the time by, you know, this is war. And it took 70 years to formally acknowledge that failure, to understand that we are in an emergency situation, but we're certainly not in a war. And the US Supreme Court has said that during a war, for example, the intentional destruction of enemy property is not something that the government is responsible for remedying or paying for. So, for example, the famous case is during the Civil War, the Union Army blew up train tracks and bridges in Confederate territory in order to prevent the rebels from using them. And after the war, the railroad company asked for compensation for the government for a taking of its property. Now, here's your first legal point of the day. The US Constitution and the Hawaii Constitution both require that private property is taken for public use, a very distinct legal term. The government owes just compensation to the property owner. In other words, when your property is effectively pressed into public service, most often through the exercise of eminent domain, but also if the government limits your use of property such that it deprives that property of all use and value, the constitutions require that you be paid for it. It's unfair, the theory goes, that a single owner bear the burden of what are unquestionably public benefits. So the railroad sued for a taking. You blew up my bridges, you tore up my tracks in order to win the war, and that's a great thing, but why should I have to shoulder the burden for that? And the court said no. The Supreme Court of the United States said no. This is war. This was to keep your property from falling into enemy hands, and therefore no compensation. And we've seen some efforts to analogize the ongoing situation, saying, well, we can ask you to shut down your business, and for example, because you're using your property kind of like enemy property. You know, it's injurious to the public health, and we're at war with coronavirus. So let's keep the war analogies away, if you don't mind, because I said this isn't one, it's an emergency. And the way that they're treated in the law is completely different. The government isn't trying to prevent your business from falling into enemy hands when it tells you to shut down for the public health. And okay, with that, let's you know, armed with the Constitution in our left hand and our spam in our right hand, let's turn to some of the more prominent questions that have arisen recently about the various orders the government's put out to do or not do things, all in the name of protecting the public health and the coronavirus crisis. You know, one thing, just a little bit of maybe perspective. The present emergency is simply the latest in a long line of events that we in Hawaii are unfortunately used to. For example, in 1900, the government officials accidentally burned down Honolulu's Chinatown when they purposely started fires to respond to an outbreak of the bubonic plague, which kind of makes coronavirus look like child's play. We all know, of course, Kalaupapa is famous as a place of quarantine for the victims of Hansen's disease. And Sand Island, in just off on the other side of Honolulu Harbor, anyone know the original name of Sand Island? Well, I can't hear you if you called out, but yeah, Quarantine Island. That's because that's where they quarantine people inbound off ships if there was some suspect who had potentially a communicable disease. And of course, Americans of Japanese descent were interned after Pearl Harbor up in Honouliuli. And so I'd like to take you back to an 1880s case decided by the Hawaii Supreme Court. It was the Kingdom at the time, so it was the Kingdom Supreme Court. Kingdom officials barred commercial laundries within a certain radius of the intersection of Nu'uanu and King, and they barred it because it was believed that dirty laundry was injurious to the public health. But anybody who's familiar with downtown Honolulu knows what part of town they meant, and that's Chinatown. But in other parts of town and in other parts of the kingdom, commercial laundries were allowed, and within Chinatown, non-commercial laundries were allowed. So the objector, a fellow called Tong Ki, pointed out that the measure was both too broad and too narrow and couldn't really serve the purposes that it was designed to do. What we lawyers call it wasn't closely tailored, and the court should strike it down as unfair and irrational. And the court rejected the challenge. It said that government officials, well, they had an arguable reason for doing this, and even if it was over-inclusive or under-inclusive, it wasn't up to a judge to make that call, that it was a call by an elected official and not a judge. So this case is really well within the mainstream of both Hawaiian law and of American law. And I raised this case, this decision, only to point out that it wasn't even an emergency in that situation. It was just designed to protect the public health, merely the government doing what the government does. And even there, in the absence of an emergency, the courts paid a high level of deference. The court didn't seriously question the means used to accomplish the stated goal. And what I'm getting at here, and again, here's another takeaway point, is that even on the most normal of days, courts are highly deferential to government claims that it can control your behavior, your business, and your property, all in the name of the public health, safety, and welfare. And if one thing is certain, and I think we can all agree on, these days are not normal days. So courts are going to be looking at any such claims like this with an even more skeptical eye. Now, there may be circumstances where the courts may take a harder look. And for example, at about the same time in San Francisco, there was a belief that bubonic plague was suffering an outbreak, and city officials quarantined Chinatown. The problem is they only quarantined Chinese people in Chinatown, and non-Chinese people were free to come and go. And so when the federal court took a look at that, it struck down the measure. And the difference between that case, say, and the Hawaii case we were talking about just a minute ago, was that there was some pretty strong proof that the reason the city officials did this was not to prevent the outbreak of bubonic plague, but it was an anti-Chinese discrimination. So the lesson from these cases is, although on one hand the courts will be very deferential in the usual circumstances, if fundamental constitutional rights are involved, in that case it was to be free of racial discrimination. But for example, members of the press, the media, if there's restrictions put on where they might be able to go or their activities, or religious gatherings, for example, those are probably going to be looked at with a slightly more inquisitive eye by the courts. And you'll see the courts maybe being more likely to step in. So tip put on your lawyer's hats. When you're looking at these type of situations, ask yourself, is this some general measure, or is there some fundamental constitutional right involved or being impacted? If so, maybe there's a better chance of having a challenge succeed. Second, ask yourself, what is the government prohibiting? Is it a blanket prohibition? Nobody can go outside, between certain hours? Or is it some more tailored limitation? Nobody can go to church. In the latter circumstances, the courts are probably going to take a little harder look. The famous case we have, well, I want to get to questions, so I don't want to get into the detail too much of things, but, are there limitations to the principle that the government kind of has free rein to do things without serious judicial interference? Well, of course not. And here's some illustrations of things I think we might see. Let's go back to our railroad case for a minute where the Army blew up the tracks. What about if the government were to, say, take over a hotel or in order to house doctors, nurses, soldiers, sailors, other things? Brings to mind the aircraft carrier that's now out of commission on Guam, and 5,000 sailors somehow looking for housing on Guam. Can the government simply order a business owner, a hotel owner, or a homeowner even to allow occupation, not provide compensation? Is this different from the railroad case? Short answer, yes, it's different. The courts have said this is different. It's not enemy property. We're simply taking over property for public use. And in that case, compensation will very likely be required. So here, your next tip of the day, if the government action in the name of public health, safety, or welfare impacts a property owner's rights to occupy his or her own property, the courts are much more likely to require compensation, even if the government has a very good reason under the public health power to commandeer it. But what about this? Let's say a little more nuanced situation. Government doesn't come in and say you have to put up doctors in your hotel. What if it says we're suspending rental obligations, or we're putting in place an eviction moratorium? That you're kind of letting the tenant occupy property without paying for it, right? And we've seen some examples of this, eviction moratoria, even though we haven't really seen what I would call rent holidays. And an eviction moratoria is where the government is saying your ability to collect rent or to enforce a eviction, or to bring an eviction action to evict a tenant, is suspended temporarily, and there's no lessening of the owner's ultimate rights to eventually, say, collect the rent once this is over, or evict the tenant. I think those will very likely not be well received by courts, as long as the owner isn't being permanently deprived of their right to evict the tenant in the future, and may be able to collect rent at that time. But we've also seen calls for, again, what I would call a rent holiday, by which there is no rent. In other words, the government wipes out the obligation to pay rent during the time of an emergency. And I think those cases, and at least in my own thinking, are much more likely to require compensation. Maybe not right now, but maybe when this is all over, and especially if it's a situation where the lack of rent jeopardizes the owner's ownership of the property. For example, if the owner has a mortgage that they usually pay with the rent that comes in. So you lose your property because you've lost your rent. And that raises the ancillary question about remedy that we often get as lawyers. Can you stop the government? Let's say you've got a pretty good case that the government's gone too far, that it's exceeded its powers or otherwise. Can you stop the government versus what I've primarily been talking about, seeking after the fact compensation? In my view, that's quite unlikely. Actually stopping the government right while we're in the middle of this is something I think a court will be very, very unwilling to do unless the government is acting outside of its powers. And we've seen cases like that in the past from the Supreme Court of the United States, where, example, even during the Korean War, President Truman seized steel mills in order to continue production without being affected by a steelworkers strike. And the Supreme Court of the United States struck that down. But so far, we've seen a lot of lawsuits, a number of lawsuits filed around the country, none yet in Hawaii, as far as I can tell, seeking to stop or enjoin these stay home or close down orders, none of which has been anywhere close to successful. So let's wrap it with some takeaway points. First, government can occupy private property now and pay you later, as long as it has the obligation to pay you later. Second, if the government takes over your business and operates the business itself, for example, if you're a hotel and it takes over your business to house doctors and nurses, the Constitution, no question, requires just compensation. Third, what about if the government orders your business to shut down or decides that it's not essential, so you can't stay open? All I ask you is remember this: government can make you get a vaccine. That was decided 100 years ago by the US Supreme Court. And if it can violate your bodily integrity, it can likely tell you to stay home without a court seriously questioning that. So again, even in normal times, courts give the other branches of government huge latitude in these things, and this is hardly normal times. So unless there's clear proof, and this is your final caveat, unless there's clear proof that the government's doing this for some other reason, such as to impact the media, impact the right of freedom of speech, freedom of press, freedom of religion. So let me leave you with this before we turn to the questions. This is an emergency, not a war. We still have rights. It's up to you to remember those and assert them. We still have to guard against inroads of those rights while still, like I said, stocking up on spam and keeping that spam in the right hand. The big danger, and I think this is the one that we'll have to guard against when this is all over, is the worst measures, the most intrusive measures onto personal liberties are adopted under the guise of an emergency. We have to make sure when we get back to normal, and I'm very much assured that we will, that we hold our government to account either through the process of the legislative or petitioning government process, or if necessary through the courts, to make sure that what were adopted as temporary restrictions on liberty don't mature into permanent restrictions that, like the frog in the boiling water or the boiling pot, that we just got used to. So with that, thank you. Let me turn it back over to either Joe or Joe and Keli'i. I ran a couple minutes over. I'm not butting up against any kind of deadline at the end of this, so I'm happy to take questions as they come in.
You did a great job, Robert. Thank you very much. And it was very insightful, as always. If you're with us online right now, we welcome your questions. Simply type them out and Joe will field them to Robert. And before we get to that, let me just say this, Robert, your statement at the outset was that one does not surrender one's constitutional rights during a crisis. But I want to ask you this question. What's the difference between law and what the courts say law is in this context?
Oh, that we could have a whole separate hour or two on that question alone. I mean, as lawyers, we look at what courts say the law is as what the law is. Now, of course, there's all sorts of ways to adopt and make law. You know, the first, of course, is by the people we elect, legislatures with the executive branch mixed in. And our old civics courses would tell us that the legislature makes the laws, the executive enforces the laws, and the courts interpret the laws. Well, you know, that may be playground constitutionalism again, because every branch makes and enforces law. What the courts say is binding, and you know, it is the other branches, especially in Hawaii, follow what the courts say. So we may not agree with it, but until a later court overrules it, or a legislature changes the underlying statute, for example, or the people through the Constitution, let's say, amend the Constitution, judicial decisions about what the law is are equally as, what should I say, binding on all of us as a statute or even the Constitution itself. So if you simply say, well, a court can't make law, I'm not going to follow it, I think you do so at your peril.
All right. Well, I'll do so when you're representing me.
Okay, now we've very good. That's a deal. That's a deal.
Several people standing by with questions. Once again, if you'd like to ask anything, go ahead and type it up. I'm going to hand it over to Joe so you can moderate the question and answer time and field those questions now, Robert.
Sure. We've got a lot of great questions coming in, so keep them coming. This one comes from Mark Monoscalco. He says, government can take private property, but must provide just compensation. But what about due process that should be required prior to the taking?
Good question. Very good question. And this is, I think, a very knowledgeable question from Mark. And we'll get back to the lawyer's constitution, where we have separate provisions in both Hawaii's and the U.S. Constitution, which not only, as I mentioned, prohibit the taking of private property with compensation, without compensation, but also, as Mark said, sets up a certain procedures that must be followed before you deprive someone of property. So we see these most often in criminal proceedings, and the idea of due process. So if you have some kind of recognized property interest, the courts, Hawaii courts particularly, have been very, very good about this, saying that before the government can deprive you of that property, it has to give you fair notice and fair procedures. Now, those standards vary case by case, depending on a whole bunch of different factors that I won't get into. But it's a significant limitation on the power to simply go ahead and seize your property, let's say, or destroy your property, unless, and this is where the emergency exception might come in, or at least the emergency cases that I mentioned. And there's a famous one out of the state of Washington called Miller against Shane. And this was sort of only a lawyer could come up with this situation. And this is where cedar trees harbored a disease that was harmful not to the cedar trees, but to nearby apple trees. And so the state of Washington told the owner, destroy your cedar trees, they're harming apple trees. And Washington, it's not too hard to figure out that apple trees are probably more important to the economy of Washington than cedar trees. And the cedar owner objected, and he said, wait a minute, they're not hurting my trees. I have cedar trees, and this blight doesn't hurt my trees. It only hurts apples. That's not my problem. And the court, over a due process, rejected a due process challenge and said, no, this even though you have to take the hit for this, yeah, you're entitled to some notice and some hearing, but ultimately the owner of the cedar trees couldn't stop the state of Washington from ordering him to destroy his own property in the name of the public health, or in this case, the health of the apple trees. And that's a pretty severe case, but also a very good illustration of, on one hand, or three things actually, how much courts defer to the judgments of elected officials, how little due process actually stands, even in non-emergency times, stands in the way of overbearing government action, and three, that due process itself isn't much of a hurdle for a court to overcome in terms of notice, hearing, and the fundamental fairness of the action itself.
Okay, we have a lot of questions. I'm going to lump them together about.
Okay. And
go ahead.
I will try to keep the answers shorter too.
Yeah.
The danger is you're giving me an open mic, and give a lawyer an open mic. That's dangerous.
Okay. We have a lot of questions about what about, can a cop stop me or arrest me for walking on the street? Can they just pull me over? What about going to the beach? I mean, is this all constitutional, or is this some kind of argument to protect ourselves against this?
I think the short answer to that is in our first quotation, right? Let me share the screen for a minute, right? This quotation: emergency does not create power. A police officer has the same ability to stop you during this emergency that he or she does any other day of the week. So in other words, I think they have to have reasonable suspicion that a crime was being committed, or maybe probable cause. Forgive me, I'm not a criminal law practitioner, so I don't know the exact standards. But there's no special thing that says they can simply stop everybody. Or in some cases, we've seen challenges, for example, to roadblocks. And there's an established set of guidelines that the courts apply in non-emergency situations to tell you whether a police officer can stop you on the street or can stop everyone, say, on a particular street from going down way by via a roadblock. It's not an unlimited power, and they have to have, my understanding is they have to have either reasonable suspicion that a crime's been committed or even probable cause. You know, maybe that, and they have to be able to articulate it. Are you in, you know, in ways that will make sense to a judge if challenged? Are you in the wrong part of town? Are you in a place, you know, are you out after the 11 p.m. to 5 a.m. driving curfew? Were you not able, you know, are you in medical scrubs, for example, and are therefore kind of presumed to be maybe a doctor or a nurse going to work? I don't know. But the short answer is emergencies do not increase the power of government agents to stop you on the street. You know, again, and we'll go to the second picture, you know, keep your spam in your hand and decide, is this the hill you want to fight on when you make that call? Do you want to cooperate, or do you want to whip out your copy of the Constitution and say, you can't stop me? And next thing you know, you'll be in a coronavirus-filled cell with about 20 other people. You know, ask yourself, what's my most prudent course of action? And maybe sometimes stocking up on the spam is better than drafting the lawsuit. Anyway. And maybe a related one to that is the beach, because a lot of people have asked about that. In Hawaii, beaches are public, right? So don't we have a right to go there? If I'm a native Hawaiian, don't I have certain constitutionally recognized cultural and native Hawaiian rights to go practice my culture and religion on certain places and certain sites? Well, my short answer to that is no right that I know of in the Constitution, that the Constitution recognizes, is an unlimited right that gives you the right to do anything. They're always subject to regulations, time, place, and manner uses, and things like that. So keep that in mind as you ask about particular places, that, again, on the best of days, your constitutional rights are not unlimited, that they are exercised subject to reasonable restrictions. And most courts, I think, will look at the measures that are being taken through the eye that these are probably going to be reasonable restrictions. Now that there's the cases we've discussed or the situations, there may be exceptions to that sort of general vibe, but I think that's the presumption that the courts will start with.
We have a few questions about President Trump's statements about total authority over the states and on opening, and also another question related about whether the federal government could require vaccines.
You want to do the? I mean, why don't we do the vaccine question first? Sure. I think because that one I have a very specific answer to. Is there? So can the federal government require you to do a vaccine? Let's say if you have religious objections to it. Chances are yes. There's a case from, I think, the 1920s or 30s on that very grounds where anyone who did not voluntarily submit to receiving a smallpox vaccine, if I remember correctly, was subject to a $5 criminal penalty. The court upheld it. And that was a question of somebody challenged that on their liberty. It says, my bodily integrity, I don't want a needle in my arm, in my body. And the court said, no, the public safety, health, and the risks of not doing it, you are jeopardizing other people if you don't do it. And there's overwhelming science that these vaccines work. So those combinations, said the court, your constitutional rights, what the court called, you have liberty. And then you have what the court called real liberty, which is liberty subject to your right, your obligation not to hurt other people. And walking around as a potential smallpox carrier is potentially hurting other people. Therefore, your right to true liberty has to give way to the public health. So that's the short answer on the vaccine. And what was the other one?
Oh, just whether Trump can trump the states.
That one is we'll go back to my, there's the playground constitution, and then there's the legal constitution. Federal government, the legal answer is that the federal government is one of enumerated powers, right? It can only do certain things. Everything else, the true sovereigns in this country are states, state governments, state officials. So, Trump, on one hand, must have read his Federalist Papers because his approach, generally speaking, as I see it, has mostly been one of suggestion and not of command from the federal government. So he's a true believer in states' rights, maybe on that hand, and yet his most recent statement seems to throw that out the window. And by that, I think he is actually employing the playground constitution, the one that's in our minds. The president is the leader of the nation, and we tend to look to he, or one of these days she, as setting the tone and the policy and controlling the economy, when we all know that in reality it's really elsewhere, or at least should be elsewhere under the legal constitution. So I think you have to take his statements in the different veins that they are being made. On one hand, his lack of action, maybe within the last couple of months, and his deference to the states is fully consistent with the written constitution, and I think the way that it was designed to be. On the other hand, his statements that, no, we ain't opening the economy till I say the economy is open, that's the playground constitution at play.
Okay, a question from Andrew Walden.
Hi, Andrew.
He asks about the transparency and open records law. He says basically, if a department or agency doesn't give you the open records that you request, then what needs to be shown to the court to prove that the WIPA suspension is a subterfuge and not a genuine effort to reduce COVID?
Big question, and one I think, if I remember correctly, I think I saw my colleague from Maui, Lance Collins, had made some efforts on that question with respect to the Maui County Council. But just let me give a 30-second background here for some folks who might not be familiar with the terms that Andrew is raising. What we call UIPA or WIPA, the Uniform Information Practices Act or law, is effectively our state version of the Freedom of Information Act. It's a government records act that says anything that's deemed to be a, quote, government record, and that is very broadly defined, there is a presumption that the public can access that through the normal means with little effort and low cost. And if nothing else is clear in Hawaii law, then it's this, is that there's a very, very strong policy in state law for the freedom of information, transparency, whatever you might call it. But at the same time, those same statutes, there are specific statutes that give the governor and county mayors very strong powers during a crisis, a declared emergency, to suspend statutes. Now, the distinction here is they cannot suspend the Constitution, as we know, but they can suspend certain statutes, and among them are the Freedom of Information laws. And I think the courts, if faced with certain challenges, will look at that. And I think on this one, how practical is it? Does everyone's home computer who works for the state government, who is now working at home, does that become subject to disclosure as a government record? Our courts are very, very, very pro disclosure and defining what is a government record, but they're also in favor of the privacy of individuals whose information may be revealed during the course of a request for a government record. And I forget exactly what Andrew's exact question was. I don't think.
What would you need to show to a court in order to prove that they weren't just trying to, duck your question?
In other words, use this time as sort of an advantage to say, well, we hate these kind of questions, and make no mistake, sorry, government officials, I know you guys hate WIPA and FOIA requests. Go complain to the legislature if you don't like that. In normal times, they do not appreciate the extra work that these create, as essential as they are to the functioning of government. And so I guess the question is, what do you need to show? I think it's the same type of facts that you would show any other time the government seems to be dragging its feet. Except in this situation, I would think that sort of the playing field is a little bit altered. It's not altered legally, but the factual threshold where the court might be willing to accept more the government's claims that this is really hard, which is normally not a reason to produce a government record. Oh, this is terrible. I don't want to assign employees to do it. Well, nowadays, maybe that's going to be a more compelling reason than it usually is. So you look at the same factors that you normally would look at in a government records case and amplify it. So you got to look for the hardcore evidence, I think, that this is really a delay. Let's say, for example, you've asked for this over the past 2 years, outside before there was ever an emergency, and the government's been dragging its feet. Why now? Why, and now all of a sudden it throws back at you as coronavirus is the reason we can't give you these things right now. Well, all of a sudden it starts looking like this is part of a pattern and not really based on, let's say, the coronavirus, some circumstance occasioned by coronavirus. So maybe the courts in those cases would look at it harder. At least those are the type of facts that I would look at as a lawyer if I was asked to drum up a case along those lines.
Okay, we have just a lot of great questions, and I'll probably have to send these to you later. But anyways,
would it make sense for Joe? I'm sorry to interrupt you. Would it make sense for me to give out my contact information now, so if anybody wants to talk offline, continue the conversation? I can't promise I'll answer it immediately, but I'll make every effort to get to every question. My email is rht@hawaiilawyer.com, and I'm going to, let's see here, I'm going to ht@hawaiilawyer.com. Okay, so I don't know if
okay, back it up a little bit.
Yeah, there you go.
There you go.
All right, okay.
For you now, Robert.
rht@hawaiilawyer.com.
Very
exactly.
Good. I just want to jump in and
if you can't get your question in, hit me up on email, and I'll do my best, just with the caveat that nothing I tell you can be used against me or in a court of law.
Now, we've got some great questions that are lined up already. So, Robert, may I suggest a speed round?
All right.
So, Joe, you send the questions to Robert. Robert, you take about 30 seconds or so to try to respond to each one.
That's Kili'i's nice way of saying, stop talking so much, Robert.
Okay,
here we go. What can the average everyday citizen do to push to get things back to normal? Perhaps legally too.
Okay. Well, first is just be prepared to come shooting out of the gate. It's going to take all of us to get the economy back on its feet. Keep going. Don't give up. I mean, we've been through this before. Some of us have been through similar circumstances, none quite this bad before. But talk to your parents and grandparents who ended up interned. Like my cousins were all interned in World War II, or who went through, wars, who went to Vietnam, who did all sorts of things, who survived the big Lehman Brothers downturn. We'll get through this. Come roaring out of the gate when we're done.
Okay.
Be vigilant. Be vigilant. And my legal point, that's my political point. My legal point is to be vigilant. Continue to hold our government officials' feet to the fire. And when this is all over, don't let them keep what look like temporary measures and make them permanent.
Okay, another question. How have courts responded to the fact that courts are themselves suspended in many places?
I thought very well. We've seen the courts being pretty nimble about it. In fact, the Supreme Court of Hawaii at first said all deadlines are suspended in all courts for the most part until April 6th, and then recently issued an order that told all the lawyers and the parties, well, April 6th is it. So April 6th, no more deadline, no more extension of deadlines. It's back to business as best you can. So the Hawaii Supreme Court has been particularly good about it. Jay Fidel did a session on Think Tech Hawaii last week with Chief Justice Rechtenwald, and I recommend you all go take a look at that if you're interested in that question. I think both Hawaii courts and every other court that I've been participating in has been extremely nimble about it. And judges and lawyers who may be, and parties who may have been very antagonistic in normal times, we're suddenly getting all warm and soft and cooperating with each other. So, there might be some good coming out of this.
Okay, another question from Mark White. He says, Robert, I believe the government has essentially two requirements to meet when issuing these restrictions. One, a compelling need, and two, a narrowly tailored action specific to meet that need. The question is, what defines the parameters of narrowly tailored and aren't blanket proclamations?
No. Very good question, and that's a take on the nuance of that Hawaii Supreme Court case from the Kingdom days that I was telling you about. That's true. The government needs to show a compelling need, and that it has narrowly tailored. But I think the more dispositive question that you have to ask is, who makes the decision that some need is compelling, and who makes the decision whether doing X is tailored narrowly enough to be considered constitutional? And you might think it's the courts. Well, as I think if nothing else comes out of the cases that I've talked about today and the situations, it's in most cases the courts say, no, we're just judges. You know, the unfrozen caveman lawyer routine that Phil Hartman used to do, you know, your world frightens and confuses me. Judges tend to act like that when there are claims made that a certain action by the government isn't in furtherance of some compelling need, and that it isn't narrowly tailored. So the courts tend to defer in most circumstances. So again, you have to be on guard against letting yourself say, well, how come I got stuck with, how come I can't go out when, let's say, lawyers are deemed to be essential? How come another profession isn't deemed to be essential? We're right back in the situation that the Hawaii Supreme Court looked at in 1880, saying how come only commercial laundries in Chinatown were being affected by their restriction and not everybody, if it's indeed harmful.
Another question, do you foresee the state adequately compensating businesses for their lost revenues during this time?
Tough case, let's put it that way. One, it's a general shutdown. Right now, if they were specifically pointing out business and saying, you shut down, you shut down, you shut down, not because there's any public health reason to do so specific to that business, or if they're letting some open and some close, well, then you get into those situations where it's worth taking a much harder look at whether they're singling out anybody for disparate treatment when they really shouldn't be, and whether there's any of those compelling needs and narrow tailoring going on. But, you know, in these general shutdown orders, much harder, because it starts looking like there's no back reason, like we saw in those San Francisco cases, or that San Francisco quarantine case that they quarantined, you know, only Chinese people and only in Chinatown, and let everybody else come and go. You know, in those cases, it's a little bit easier to show that, well, there's some other reason going on, but these general rules tend to apply to everybody. But the way I would look at it as a lawyer, if some of them didn't apply to me and applied to you, then maybe I'm going to look at that case where it applied to different classes of people a lot harder than I normally would. So far, none of those challenges, and there's been about 5 or 6 that I know of around the country, saying the shutdown order is irrational, it's burdening me versus somebody else. They haven't made their proof, and all of them, none of them, as far as I know, have been successful so far, even close to successful.
We got a good question from Stuart Yurton.
Hi, Stuart.
In the rent holiday example, who would be responsible for compensating the landlord? The government? And do you foresee other examples under current laws where there could be successful regulatory taking suits?
Yeah, good question. Yeah, short answer to A, yeah, the government. Private parties can't take, but if the government allows a private party to occupy property, then the private party isn't liable for that taking for compensation. It's the government itself. So it would be the government, the state, federal, or city and county, or the county that ordered the rent holiday would be the defendant in that kind of case. And I'm sorry, what was the second question there?
Oh, well, let's see here.
On Stewart's, on the
sorry, I lost it. Yeah, oh, here it is. The second question is, are there other successful regulatory taking suits like this?
Hard case to you know, the Supreme Court of the United States said there are, quote, literally infinite ways in which government actions can restrict unconstitutionally someone's use of their property. So yeah, potentially, yeah, there are others. To me, that's always been sort of the most obvious one. And I haven't sat down really and thought about kind of, you know, gamed out some other possibilities out there. But they're, you know, that's why I watch the headlines to see what, oh, maybe this one, you know, is government telling you you can't use your own property? You know, we have cases or people challenging, you know, you have to stay in your house versus you can't go in your backyard, or why can't I go to a public park as long as I stay away, you know, 6 to 10 to 20 feet or however far it is from somebody. Right? At that point, it's the government's just doing that, maybe, so the argument might go. It's more convenient to tell us all to stay home than to actually police what we're doing when we're doing it unsafely. So the short answer to Stuart's question is, yeah, there's a billion ways that this might turn into a takings case, but I haven't seen any just yet.
Bill Hastings asked, would a court ever decide that the government has gone too far? For example, businesses opening, you know, for months or 2 months or 6 months, or, you know, how far is too far?
You know, if it's simply a question of time, you know, they keep you closed until you go bankrupt. You know, that I hate, you know, that's a worse situation, but a better case, you know, from a lawyer's standpoint. The more the damage, the more likely it is the court will step in. But it's still a tough case, right? Again, as long as these type of regulations and limitations are applied to everyone, that is probably the best case for the government. And as long as there is at least some colorable science out there that tells us this thing is still a danger. I mean, the courts will not get into digging into who's right about whether there is indeed a threat from coronavirus. I have serious doubts about any court doing that, much less a court doing that while we're in the middle of it. They will almost certainly defer in all but sort of the most extreme cases to the government's conclusion that, yeah, coronavirus is a problem. And could it go on for a long time? Yes. I don't think the time alone is determinative of the validity from the Constitution standpoint, one way or the other.
Okay, well, I guess I have a last question here from Robin Stuber. She asks, kind of looking at the bright side, what is the biggest opportunity that this unprecedented event has opened up? Maybe that's
a great question.
Lobby for bringing in positive change or something.
Yeah.
Or,
you know, that's a fantastic question. My takeaway from this, and it's something I, as a lawyer who do constitutional law, understood, but I think a lot of people may be having their eyes open, is that, again, in the best of times, the government has a severe and overarching power to limit your liberty and your use of your property. You know, whether it's requiring you to get permits that you don't think are necessary, certificates of needs to have a food truck, let's say, or, you know, sort of classic licensing questions. What we're seeing now isn't the government doing anything more they could already do. So my message from this, my own takeaway, is to remember how you feel now and make sure that we don't necessarily even go back to, you know, pre-COVID normal. Look for ways in which this situation has taught you to make inroads on other unreasonable intrusions into your life, liberty, property. You know, hopefully in times when we're not quarantined and worried about our family, friends, and colleagues' health, you know, we can address the more serious questions of the place of free markets, right? Because as some have suggested, free markets are the way out of this. Individual responses, get your spam, right? Armor up with your spam. And not relying on the governor or the mayor or the city council to dictate, and I use that word very gently, to mandate by law what you can and cannot do. Because I think our freedoms, as we're all realizing maybe for the first time in this concrete way, are very important, and it's up to us, not them, to make sure that we keep them. So with that, maybe that's a good way to end it. And again, rht@hawaiilawyer.com. Glad to try to answer any questions you may have, or just want to send me a note and say hi.
We definitely will put your information into a note that goes out to everyone who registered for this program today. So that,
I'll also, I'm sorry, Kali'i, I didn't mean to
go ahead,
interrupt you,
Robert.
but I also want to say that I have a blog that you mentioned, kindly mentioned earlier, and all of these cases that I mentioned today, if you actually want to go read the decisions, I will post those on my blog after we get off this this teleconference, and you can go read them yourself and tell me I'm wrong about them or I'm reading them wrong. But I will make those available on inversecondemnation.com.
Very good. And thank you, Robert, so much for being with us today. And thanks to all of our viewers. We appreciate the questions, and we apologize that there were a few more questions that didn't get answered due to time, but we'll get to you and send you the information with which you can reach out to Robert directly. Be with us on the 21st for our next webinar, which will be a panel discussion about something the governor did, which was to suspend the open meetings laws as well as sunshine laws. And some groups have responded to that. Sandy Ma, the president of Common Cause Hawaii, and Brian Black, who heads the Civil Beat Center for Law. And I think I always forget the name of that center.
The Civil Beat Center for Law and Public Interest.
That's right. They will be my guests on a panel discussion about the actions taken by the governor. But until then, on behalf of Grassroots Institute of Hawaii, I thank you so much for joining us today. Again, Robert Thomas, thank you very much. And we'll see you next week, hopefully. Aloha.
Aloha.
Aloha.